Welcome back. You're watching HFO-TV.
We've been asked today to talk about Senate Bill 608, Portland City Code, and a few potential upcoming changes to that city code. But before we jump right in, how many people have read Senate Bill 608? Pretty good. And how many people have read Portland City Code 3001-085? Fewer. And how many of you felt like you understood him? Right. So we're going to try to do a fast overview of this, but I think the overwhelming thing is that these are both very complex regulations, and they require a lot of thought. They're full of loopholes and exceptions to exceptions. And so for particular questions, you're going to want to seek the advice of an attorney for your particular circumstances. But that said, Adele, what is the first major prong of what Senate Bill 608 does?
Well, Senate Bill 608 does a number of things. I think there's what we consider to be three prongs, but I'm going to shoot a question back to you, Ciaran. Does Senate Bill 608 impact for-cause terminations?
No. If you could terminate somebody for cause before Senate Bill 608 existed, you can terminate them for cause after Senate Bill 608 passed. There's no change there.
Okay, so the first major change for Senate Bill 608 is that it eliminates no-cause evictions are no longer allowed after the first year of tenancy, subject to certain exceptions. And when I say exceptions, that's a word you're going to hear a lot today, because there are a lot of exceptions to all of the portions of the bill and exceptions to the exceptions. So first of all, I guess we need to talk about what does the first year of tenancy mean. Under ORS 90.427A, first year of occupancy includes all periods in which any of the tenants has resided in the dwelling unit for 1 year or less. So question for you, Ciaran. If I have a tenant that has been living in my unit for 5 years and they have a girlfriend, and that girlfriend joins and suddenly signs on to the lease, can I do a no-cause termination?
Yes. You are now in the first year of occupancy because you have two tenants, and that one of those tenants is in her, in this case, first year of residing in that dwelling unit. So the first year of occupancy is a confusing term, but it applies to all the different tenants in play. And that's not a change in 608, but it becomes more important because of the other changes in 608.
Okay. So if you want to do a no-cause eviction after the first year of occupancy, you do have to fall within certain exceptions, otherwise there may be penalties apply, and we'll talk about those penalties later. The first exception is if the landlord is terminating the lease for what's known as a qualifying reason, and there are 4 qualifying reasons. The first is that a landlord intends to demolish or convert the unit into something other than residential use. The landlord intends to make repairs within a reasonable time, and the property is either unsafe or unfit to occupy or will be rendered as such during the repairs. Now, there's also a situation where a landlord or a member of their immediate family plans to occupy the unit, and the landlord doesn't have a comparable unit to provide to the tenant, or the landlord has accepted an offer from someone to purchase the unit, and that person plans to reside in the unit. And in that case, the landlord also has to have given a 120-day notice of the acceptance of the offer for purchasing or for someone purchasing the unit. Now, question, going back to the reasonable, or the repairs within a reasonable time, Ciaran, what does that mean under the law?
It means a reasonable time. So if you're evicting somebody, terminating for no cause because you intend to repair, you've got to do the repairs in a reasonable amount of time, and what you have to be worried about is if how long you take to do those repairs would appear unreasonable to a plaintiff's lawyer, to the tenant whom you terminated, or to a Multnomah County or Oregon jury in any of those cases.
And so if you qualify under one of those 4 qualifying reasons, you can terminate without cause, but you first have to send the tenant a 90-day notice of intent to terminate, the reason for your termination and supporting facts, and you also have to pay 1 month's rent to the tenant. That is a statewide new rule under Senate Bill 608. There is an exception to the 1 month's rent requirement. Ciaran, can you explain?
Yeah. under the Act, now, if you own 4 or fewer units, then you don't have to pay this 1 month rent if you are terminating a lease under one of these 4 permitted landlord exceptions. So that's an interesting question, right? How do I know if I own 4 or fewer units? It seems really straightforward if you've got you've got an ADU in your backyard and that's what you rent out. But it gets a little more complicated, and there are a couple ways that people might be kind of crafty about that, right? What if I've got a building that's got 5 floors with 4 units on each floor? Can I divide up ownership of that building so that each floor is owned by a different LLC, and therefore none of those landlords, the ones that own the units that they're renting out, owns more than 4 units, and they're not subject to having to pay this 1 month relocation, this 1 month rent.
And kind of to add another potential craftiness to that, what if you're a landlord that owns multiple buildings, but all of those buildings are 4 units or less? Can you do the same thing? Because the law is interpreted in the aggregate. So if you own one building of 4 units, but then also own a second building, can you do it?
Well, it's risky, is the bottom line. It does talk about the landlord, and then you have to go back to the definition of what is a landlord under the Act. And that's in ORS 9100. It says landlord means the owner, lessor or sublessor of the dwelling unit, or the building, or premises of which it is a part. And landlord includes a person who is authorized by the owner, lessor, or sublessor to manage the premises or enter into a rental agreement. So you might try to divide up your multi-story building, but you might own the building itself, or you might hire a manager to run it for you, and that manager might somewhere else, completely separate from you, own more than 4 units in a different building. They might be an owner-manager or something like that, in which case you might be subject to that. That also raises the question of what happens if I really do only own 4 units, but I use a management company that happens to own more than 4 units somewhere else. Does that make them a landlord under this Act and subject me, even though I only own 4 units, to this need to pay 1 month rent? The answer is maybe. It's risky. Again, this is why, if you are terminating for one of these reasons, you want to talk with a lawyer. You can probably help limit your risk by having you personally send the notice, or the owner entity send the notice rather than the management entity send the notice. But these are some of the problems that happen when you have a hastily written bill written to try to address some of the emergency that we just heard about.
Moving on to one of the other exceptions to the no-cause terminations after first year. Another exception is that if the tenant occupies a unit in the same building with the landlord and the building contains no more than 2 units, in that circumstance, you can terminate without cause after the first year of occupancy. For month-to-month leases, it's with 60 days notice or with 30 days notice if the dwelling is bought separately from the other unit and the landlord has accepted an offer to purchase the unit from someone else who intends to occupy, and gives notice and evidence of accepting the offer to purchase to the tenant within 120 days after accepting the offer. For fixed-term leases, you have to give 30 days notice.
That's 30 days before to allow it to terminate at the end of the fixed term. Fixed-term leases, you can't terminate during the term except for cause. So that's the first major prong of what 608 does. What, Adele, is the second?
So the second is what we're calling statewide rent control. Rents may not be increased, first of all, during the first year of tenancy. After the first year, the rent increases require 90 days notice to the tenant and are limited to 7% plus consumer price index, which during the current year for 2019 is 3.3%. CPI is calculated each year in around the September-fall time. So right now it's 10.3%. After the first year is the cap on what you can increase rent, subject again to various exceptions. What's some of those exceptions, Ciaran?
Well, there's a couple, but I want to touch on one thing quickly. That this first year of the tenancy, that's different than the first year of occupancy that we talked about in the last one. First year of tenancy means that if your girlfriend moves in and you both go on the lease, at that point, that is not the first year of it. It's the first year of occupancy. It's not the first year of tenancy. You could raise rents
Right.
if it were, say, month to month.
Okay, so what's one of the exceptions?
So the first and probably most important exception is for buildings that are 15 years old or newer. This is a rolling deadline. It's not a one point in time, but if your first certificate of occupancy was issued less than 15 years before you issue the rent notice, then you can go ahead and raise it more than the 10.3% cap under state law.
And there's some policy reasons behind that. They figured when new construction is still 15 years from the certificate of occupancy, we want to wait to see if rents have stabilized for that building, if it's new to the area, making sure that it's got an adequate vacancy rate before we start limiting the landlord's ability to raise rents. So another exception to the statewide rent control is that if the landlord provides reduced rent as part of a federal, state, or local subsidy. And this can be a confusing exception. People think they can apply for it if, for example, they accept Section 8 housing. Is that true?
Yeah, this has to be a subsidy that is provided by the landlord. So if you have a tax abatement or something that is conditioned on you providing lowered rent, that's one thing. If you just accept a Section 8 housing voucher, that's not you subsidizing anything. That's just you accepting somebody else's subsidy. So to be allowed to invoke this exception, it has to be the former. It has to be some way that you are providing lowered rent.
So if you're a landlord or owner of an apartment building and you have applied for a HUD program to be able to dole out certain restricted rents that are tied to your income, that would qualify, but not the acceptance of a tenant's subsidy that it's providing. So the third exception is if the landlord may reset the rent to market rate at the start of a new tenancy unless the landlord did a no-cause eviction with 30 days notice to the tenant or terminated a fixed-term lease during the first year of tenancy for the prior tenant. In that case, you're not allowed to reset the rent greater than 7% plus CPI. And are there potential loopholes to that?
Yeah, so there's a couple things going here. Really, generally speaking, if a tenancy ends and you get a new tenant, you can reset the rent to whatever you want it to be, market rate. There's one exception to that, which is the one Adele just mentioned, which is if you terminated the prior tenancy for no cause, then you're not supposed to raise rent for the replacement tenant more than the state maximum 10.3%. That said, all it said, that the language in the statute just says for the next tenancy. It doesn't say for the next year. It doesn't say for the next 6 months. It just says for the next tenancy. And this is a hole that even plaintiffs' lawyers that I've met out there, tenant advocates, have noted in this current legislation, because what it allows you to do would be to have a next tenancy, say to your spouse, for a week, that is the next tenancy, and then thereafter, you could raise the rent more than the 10.3% for the tenant that follows after that. Is that a good idea? It depends, again, raise it. It's certainly against the spirit of what this law is saying, and when this was pointed out to some enforcement folks, I think they were a little alarmed and angered by it, but this is, again, what happens when you have sloppy drafting in a law that gets rushed through. This may well be, the plaintiffs' lawyers that I know are advocating to try to get this loophole filled, but they are at the same time acknowledging that it is something of a loophole.
And we recently checked, as far as we know, there is no legislation pending to correct this loophole. However, we are watching it closely. As Ciaran said, it is risky because if you come up against a tenant who's lawyered up and wants to fight this and thinks that you're going against the letter and spirit of the law, and a judge agrees with them, there are significant penalties.
All right, so what is the third sort of prong of Senate Bill 608? So
the third prong has to deal with fixed-term tenancies automatically rolling over into a month-to-month situation. Many of you may have fixed-term leases that's a standard clause, that once the fixed term expires, it automatically becomes month-to-month, and that was generally how most leases operated in Oregon. Now, fixed-term leases expiring after the first year of occupancy automatically become month-to-month leases unless certain exceptions apply. What's one exception, Ciaran?
Well, there's the obvious ones, right? There's if you enter into a new fixed-term lease, then the lease doesn't become month-to-month, it just becomes a new fixed-term lease.
Another exception is if the tenant decides that they want to terminate the lease and move on. That, again, obviously, it doesn't roll into a month-to-month in that case.
Right. But the one that is interesting and should be interesting to everybody is what's been called the three strikes rule, which basically says if you have 3 lease violations over a 12-month period, then you can allow the fixed-term lease to expire at the end of its term. It's different than a for-cause termination. You're not saying, look, we're cutting this off early. You're just allowing it to expire, and you don't have to renew it. There may be certain advantages to that, both from the tenant's point of view and from the landlord's point of view in terms of what you need to go through. That said, in order to allow for that to happen, you still have to document those 3 violations and do so in a pretty rigorous way. Most notably,
It specifies you actually have to give the written warnings of the violations at the same time as the violations. You also have to provide your notice of termination with the 3rd strike, or if it's based on the 4th strike, at that same time.
that's right. So there's a lot of specific notice requirements in the Act. You'll want to consult your attorney to make sure that you're meeting all of those requirements. But the area that I think there'll be disputes over for landlords invoking this is that the Senate bill says at the time of each violation is when you provide this notice. Now, what is at the time? Does that mean if somebody's walking their dog and they don't clean up the mess, that you have to run up to them before they walk more than 5 feet away and slap them with a notice? Probably not. Does it mean that you can wait a week before you send them a notice in the mail about that? Yeah, that's probably pushing it. So it's somewhere in between, but you have to do it promptly, and you have to recognize that the more promptly you do it, the better off you're going to be in the event of a dispute.
My guess is 24 hours will probably be considered okay, but anything beyond that might get into dicey situation, depending on the violation, of course. But.
Right.
And no relocation assistance is required regardless of how many units the landlord may owe in that case. However, you have to also check local ordinances, and that kind of leads us into our Portland ordinance, but we want to get to penalties, I think, first.
Right. So if I'm trying to comply with Senate Bill 608 and I screw up, what am I up for?
So some pretty significant penalties. The first is that you can, if you get challenged on any one of these violations of Senate Bill 608, you could be subject to having to pay the tenant 3 months' rent plus the actual damages of the tenant. So what does that mean? If the tenant has to move out and has hired a moving company and has incurred a whole bunch of additional costs, you may owe the tenant those as well as the 3 months' rent. Potential risk of attorney's fees under the Oregon Landlord Tenant Act. The tenant will now have a defense to eviction for non-payment of rent, and also additional penalties under local ordinances depending upon where the property is located.
So be careful.
The statute of limitations for a tenant to bring a violation of Senate Bill 608, it's 1 year from the violation.
And 1 year from discovery.
Discovery, sorry.
So reasonable discovery. So either they knew or they reasonably should have known that there was a violation.
Yeah. So that leads us to talking about the interplay of 608 with Portland's City Code Ordinance. So what does Portland City Code Ordinance 30.01.085 set out, Ciaran?
So this is Portland's renter additional protections. This was an ordinance adopted back a while ago, but then amended in response to 608 in March to clarify a few overlapping areas. And really it has 2 main prongs. The first is that it tries to do away with no-cause evictions, and it tries to put a cap on how much you could raise rent. But it doesn't do it in those words because we have a law in Oregon that says local municipalities and other governments can't implement rent control. Only the state can do that. So what have they done? They've done 2 different things that way, and they frame it in terms of not limits but consequences for doing certain things.
So if it requires 90 days notice if you want to terminate without cause, and it requires the payment of relocation assistance with notice to the tenant of their rights to the relocation assistance, which can be anywhere from $2,900 for a studio or a single room occupancy unit to as much as $4,500 for a 3-bedroom or larger unit. That relocation assistance is in addition to any amounts that might be due under the Senate Bill 608 if you have to pay that 1 month's rent for no cause eviction, unless the payment of the larger between Portland City Ordinance or Senate Bill 608 is paid with the notice of termination to the tenant. So in that case, basically, almost always Portland City Code is going to be the larger. So you may be able to avoid paying the tenant the 1 month's rent under Senate Bill 608, but still have to pay the relocation assistance only if you pay the relocation assistance with the notice of termination.
Right. It's complicated.
Complicated.
But essentially, so if you've got it, this is for no cause termination. You've got a no
Right.
cause termination, you've got to send the 90 days notice. Under the state law, you have to provide the 1 month rent as soon as you send that notice. Under the city law, you wouldn't have to unless you want that 1 month rent to count for both. And if you don't do that, if you don't pay the larger of the two amounts, then you will have to, 45 days after sending that notice, pay the relocation assistance in addition to the 1 month rent.
And remember, these are no cause terminations, evictions, not for cause.
All right, what if I'm declining to renew or replace an expiring rental agreement?
It counts.
That's a no cause termination under the Portland ordinance.
Yeah. So as Ciaran said, the Portland ordinance also puts a cap on rent raises. It's the same 90 days notice is required if you're going to raise the rent, and it's for anything that is 10% or greater. So 9.9% raises in a 12-month period of rent is okay, but 10% is not. So obviously lower than Senate Bill 608.
Right.
So what does that mean?
Well, it means a couple of things. One, when we say it's not okay, you can do it. You can go
Yeah.
ahead and raise your rent in Portland 10.2, 10.3%. That's the only real limit is the state thing. But if you do that, and the tenant, when you send the notice, you have to tell the tenant that they have the right to request relocation assistance. And they have 45 days to ask you to pay them relocation assistance. So if within that period they ask you, you've got to pay it. That's somewhere between $2,900 and $4,500. Then they get to hold on to that money for 6 months while they decide whether or not they want to move out and pay that higher rent, or if they want to move out or pay that higher rent. They can do either. If they decide to pay the higher rent, then they have to pay that relocation assistance back to you, but they hold the money during that time, and they don't leave just because you pay.
Good luck collecting.
Right.
The one part of the Portland City Ordinance, it's a caveat. It says the tenant can only request and retain relocation assistance one time per dwelling unit. So if you send, for example, 2 rent increases above 10% or at 10% or above, and the tenant is perhaps still in that 6-month waiting period where they're deciding, you don't have to pay the relocation assistance yet again.
Right, or put differently, if you send a rent increase notice and they're thinking about it, and then you do a no-cause eviction, you don't have to pay it a second time.
Yeah. Yeah. So penalties under the Portland City Ordinance, similar to Senate Bill 608, you have to pay the relocation assistance amount depending upon how large the dwelling unit is, up to 3 months' rent, actual damages of the tenant. There's also an attorney fee right to the tenant potentially, and it's a one-way tenant attorney fee right. So basically, if the tenant wants to go into court and say that you have violated the Portland City Code, they may be entitled to their fees, but according to the city ordinance, if you win, you are not. How does that interplay with Oregon's Landlord Tenant Act and its attorney fee right, which is reciprocal?
Right, it's a problem. So you can get sued under this ordinance, and even if you win, you don't necessarily get your attorney fees back. Of course, under the Act, there's a reciprocal provision, and there might be some argument that should control. It says suits related to rental agreements, that attorney's fees should be shifted in those circumstances. You could argue that that's there. You might try to put a provision in your lease that allows for reciprocal arguments, but even that is somewhat risky because it may be a provision that is not permitted expressly by ORS 90, in which case you could be liable for damages under ORS 90 for trying to shift attorney's fees under the Portland City Code. Consult a lawyer.
One question I have, and this is an avenue to be explored potentially with a tax advisor or CPA, is if you do end up having to pay any relocation assistance or some of these other penalties, either under Senate Bill 608 or the Portland City Code, one good question for your CPA or tax advisor is it a business deductible expense that I can now include? So something to think about. This leads us to our next topic, which is preemption. So first of all, just as a general understanding, what is preemption? Preemption is basically a theory in the law that says, and Ciaran touched upon it earlier, we as the state have decided we want to regulate certain areas of the law. You as a local municipality, city, county, you are not allowed to interfere or regulate that particular area. And as it relates to rents, ORS 91.225 states that a city or county shall not enact any ordinance or resolution which controls the rent that may be charged for the rental of any dwelling unit. So it kind of presents the question, does the new Senate Bill 608 and the other portions of Oregon's Landlord-Tenant Act that already existed preempt Portland City Ordinance?
Yeah. Or put differently, does ORS 91.225 mean that Portland can't enact its attempt at rent control even though it doesn't call it rent control? And I think, Adele, tell me if I'm wrong, but this is the subject of much controversy.
It is. So there's two cases. There's one that's currently up with the Court of Appeals that was decided by Judge Henry Bright-Hopt. He's a retired tax court judge. And then there's another case that was decided by Multnomah County Judge Judith Matarazzo, most recently, handled by our two partners, Gabe Weaver and Jim McDermott. And in one case, Judge Bright-Hopt found that state law did not preempt Portland's city ordinance. In our case, we were successful in having Judge Matarazzo rule the exact opposite way. Judge Bright-Hopt's decision is up with the Court of Appeals, and it was recently argued in January, and we're expecting an opinion in about a year and a half. The Court of Appeals is a court that handles a lot of cases. Criminal docket gets priority, and the typical waiting period post-oral argument is anywhere from 1.5 years to 2 years for a decision.
Yep, so stay tuned for a very long time on that.
And in the meantime, though, what does that mean for cases going forward?
Well, it means that if you are sued under the Portland City Code, you have a good argument, one that has convinced at least one Multnomah County judge so far that it can't be enforced, that it's contrary to state law. So again, a risky thing to do. You don't want to be in litigation in the first place, but if you find yourself there, it's an avenue worth pursuing.
And I can tell you that the way courts interpret other fellow trial court decisions is that it can be persuasive authority, but it is not binding on them. So if you have this case and you're before Judge Matarazzo, congratulations, you have a pretty good idea of how she's going to rule, but my guess is that if you have some other judge, you just don't know what they're going to do. So that leads us to what are some best practices for landlords?
So there's a few different things here. Number one.
You're all laughing and we understand.
If it wasn't clear from our presentation, that's because this is a very difficult topic. And so you really do need to consult a landlord. Circumstances can vary widely between unit, between tenant, between type of tenancy, and between based on your lease terms and where exactly your
location,
your tenants are. So talk with a lawyer before you do anything that you think is potentially risky.
Particularly terminating for no cause or increasing rent.
All right. And of course, if you're in Portland, be mindful that there are local ordinances here. I'm not aware of attempts in other localities in Oregon yet to do something similar to Portland, but it's certainly a possibility. Which leads us, I think, to a couple of really nitty-gritty practical things. One of which I'll talk about is fixed-term leases. As we mentioned before, there's the 3 strikes ability to terminate a lease at the end of it. If you were somewhat indifferent between having a fixed-term lease and a month-to-month lease, having a fixed term gives you that extra option to allow it to expire with the 3 violations, et cetera. Maybe that's some flexibility that's worth something to you. So you might want to consider having negotiating a new fixed term when a fixed term is expiring. The other is
Rent concessions and how you can utilize those to your advantage to keep up with market rents. So to explain, let's say you have a tenant that you like and you rent that unit for $1,000 for the year, and you decide you want to increase rents or at least preserve the right to do it, but you actually like this tenant and you want to keep the rent at that level. What is a good idea you could do?
Well, so and this is just me cribbing from my own experience as a tenant in New York, where they've got even weirder rent control rules. But what you can do is you can raise the rent and then offer concessions back to keep the rent essentially the same for the tenant, which preserves then the following year your flexibility to raise to 10.3% over the rent that you had the year before. So to use Adele's example, first year of tenancy, it's $1,000 rent. Next year, you raise it to $1,100. But you say, you know what, I'm going to knock $100 off the rent each month as a concession. Then you get to year 3, and market rates have shot up, and you want to charge, let's say, $1,200 rent. Can you go from that effective $1,000 all the way up to the $1,200? If you've taken this intermediate step, you can. So it's a strategy you might want to use to preserve the ability to catch back up to market rates if you're worried about market rates outstripping whatever whatever rent that you might otherwise be able to charge.
So some other developments. House Bill 3432.
Oh, sorry. I should say, again, that's not likely to be looked kindly upon by certain enforcement regulators, so you should be careful about it and really think about it. But if that ability to preserve some flexibility is worth it to you, it's something to explore.
So, no problem. So House Bill 3432, its essential purpose is to entice builders and developers to build more first-time entry-level condominiums and townhomes. It does essentially 3 things. For only townhomes and condominium associations, it reduces the statute of repose for construction defect tort claims from what it was a 10-year statute of repose, that's your ultimate window of time to bring a tort claim for construction defects, down to 6 years, so long as the builder or developer has done certain to-be-determined special inspections. We know a little bit in the bill, but the rest of the special inspections is left to be determined by a rulemaking authority. The special inspection process will have to involve basically a design professional coming out on site and reviewing the work and signing off on the work, and it's primarily geared towards building envelope defects. A design professional in Oregon means an architect or an engineer. The bill is after that a little bit more vague in terms of what the design professional is going to be looking at, how many times they have to come out and inspect. That's, again, still to be determined. It also requires homeowners associations to seek majority vote approval of all lot owners before they proceed with a construction defect lawsuit. And that has to be done basically at the same time as they're sending out what's known as a 10-day opt-out notice to owners. So it actually is a pre-litigation vote that has to happen. And it also is seeking to amend the Notice and Opportunity to Cure Act. That is for residential construction. Before anyone can bring a construction defect claim against a contractor, developer, material supplier, you first have to give notice and an opportunity for that individual or company to come back and fix the defect or offer money to fix the defect. It requires for townhomes and condominiums a couple of weird particularities. I won't get into too much of of it, it has to do with whether or not you can object to their expert and how you mediate that. It's a little bit mercurial in terms of what its plans are for the Notice of Defect Act. So it had actually, I have here, it had a public hearing on May 1st. Well, it got continued to yesterday. I was actually down in Salem for that hearing, and that public hearing did not finish, so it's going to continue yet again. The real reason I bring this up is it kind of presents a couple of questions. Number one, how is this going to impact the rental market, if at all? If this does pass and it does what the sponsors of the bill think it will, which is create more entry-level condos and townhomes, are we going to be seeing a shift from vacancy rates in apartments to people now wanting to own in those first-time home entry-level housing? The other big question is, how is it going to impact construction practices and future requirements for new construction of apartments? Is this now going to be seen as the model that needs to apply in construction going forward for all different types of projects? There are a lot of commercial projects where this is a special inspections process of some sort is already being done, but it's not a state requirement, and now this is part of a state requirement potentially for townhome and condos. So those are two questions I certainly see coming up. The bill, right now it's with the House Rules Committee, so they have to finish the public hearing, and then if it goes past that, it will have a working session, but no dates have been set for that just yet.
And meanwhile, our city commissioners here in Portland have been busy. There's a couple of things I wanted to touch on. The first is the so-called FAIR ordinance, or Fair Access in Renting ordinance. This is this one, if you thought the ORS, if you thought the code was difficult to read before, that 608 was difficult, this one is an order of magnitude more difficult to read and understand. That said, it essentially does two things. It regulates how you screen applicants. And it says you can either go with a relatively standardized low set of qualifications, and it tells you how to do that, or you can opt for a higher standard. You can continue to use whatever criteria you want, again, subject to normal non-discrimination law, et cetera. But you can use that higher thing, but you then have to justify any time you say no to a tenant, and there's requirements about how you document that. The other thing that FAIR does is it regulates more tightly how you do security deposits and how much they can be and for what sorts of things and when they can come back. FAIR has not been enacted. There's been a first reading. There were 2 days of testimony in front of City Council. The second reading was postponed. I believe it's now scheduled for May 23rd. And we'll be keeping our eyes on that because, of course, if adopted, it will have a major impact on how landlords do business. The second thing I wanted to mention is our Commissioner Adele back on February 21st in PM session mentioned that there were 16,000 vacant units, she thought, in Portland. I'm not sure where that number came from, but she said that, and she said she was going to have the city look into whether there should be a tax on vacant units. And we haven't heard anything more from the city on that, but in the Oregonian article from a week ago this past Sunday, Oregonian did a public records request and found out that Udaley's office had explored an empty dwelling fee under which landlords would be charged $5,000 per empty unit for every 100 days of vacancy, 120 days of vacancy, with exceptions for vacancies caused by renovation, sale of the units, death of the owner, et cetera. We haven't seen anything like that turned into an ordinance. And again, this is just whatever happened to be in the public records materials that the Oregonian got from Udaley's staff. But there's something to be out there. Obviously, if anything comes out, that will be of significant concern. And we'll keep you updated.
Yeah, and I would certainly wonder its constitutional effectiveness.
There are lots of problems.
There are lots of questions about that.
Adopt that kind of act. So with that, I think it's pretty clear that talking to a lawyer about some of this stuff is a good idea.
Yeah. So thank you, everyone.
Thank you. Thank you for the information.
Our entire office specializes in multifamily real estate, making HFO the largest multifamily brokerage in the Pacific Northwest. Your success is our passion. Build your legacy with HFO. Call 503-241-5541 or visit our website at hfore.com for more information.